So, good afternoon, everyone. So I'm Olivier Moreto, Director of the Center of Civil Law Studies, in company with Jim Stoner, who is the Director of the Vogelin Institute, and we are delighted, the two centers are delighted to sponsor this great event and welcome our dear friend Santiago Legarre, who is visiting us from the Católica University of Argentina, Buenos Aires, who is a long-time friend of our law center. Santiago has visited many times and made friends with many of us, including our much regretted Cheney Joseph. I remember those days when you two were running and jogging together and having these wonderful conversations. It would take me a long time to introduce our speaker and give you the list of his many accomplishments. Santiago studied law actually at the Católica University, at the Catholic University of Argentina, but added a doctorate in law of the University of Buenos Aires and a master's in law of the University of Oxford. He's published many books in constitutional law and articles dealing with the Constitution, police, and natural law. He is published all over the world, including in Louisiana, in the Loyola Law Review and Journal of Civil Law Studies. And today, his topic is natural law and constitutional law. We are delighted that this event happens in this place. This room got quite an upgrade yesterday because we had the Supreme Court of Louisiana sitting here. So we will move things even higher with your remarks on natural law. Santiago, we are really delighted having you here as the guest of the Vogelin Institute and the Law Center. And please join me in welcoming our speaker. Thank you.
Wow, I mean, it's difficult to talk about that after that, actually. Higher, I don't know about higher. But let me say before I forget that these remarks are dedicated to the memory of my friend, our friend, Cheney Joseph. And I will read this so that I don't get it wrong. And then I probably won't read anymore. The faith in Christ I'm blessed to share with him is my only consolation for not having his smile here today. And a big consolation at that, though I can't but wish he were here. So now I feel more free, and I'll go ahead and say thanks to all of you first. I recognize in the room several people who were here 7 years ago when I gave a lecture on a not too different occasion, as Saul had left us not long ago. I remember this was in the Tucker room. And I hope and I think after my conversation today with the new dean, whose presence I acknowledge and thank, and my conversation with Olivier, that next time we won't need anyone to die for me to come again. And speaking of deans or chancellors, I also want to acknowledge and thank the presence of John Costones, who brought me here for the first time. I will never forget being interviewed by Saul Litvinov and John Costones in a hotel in Buenos Aires. You don't envy that experience, I assure you. Thank you, John. Thank you, Jim Stoner. Throughout these years, I've met Jim at an annual conference at the University of Notre Dame. And in that sense, he was like my continuity with LSU, although he's not in the law center. Is it the law school now? I won't ask, just in case. Thank you to Pat Martin, too, who was crucial for my being here. today, and his wife Anne. They've put me up in Clinton. This time I didn't ride on horse. There wasn't time, but maybe next time. And thank you to John Baker, who made a long way to come to this lecture. Thank you, of course, to Olivier, who was the one who brought me last time, already under Jack Weiss's chancellorship. Michelle Forbes, another name that means the continuity throughout these years of physical absence. Mary Joseph, who gave me this tie yesterday when I went and visited. It says Bah Humbug, and it was one of Cheney's favorites, of course. Well, all of you, thank you so much for being here today. I really appreciate your presence. The topic is natural law and constitutional law. And you see, when I leave the United States in a couple of weeks, I will have done 9 flights, 2 international flights and 7 domestic flights. And in all of them, I've had to go through the safety announcements of the new American Airlines video. I don't know if you've seen it. I think it's the only one I really like. Maybe because the leading actress or flight attendant speaking in this video has a very enthralling and endearing voice. And I won't be able to duplicate it, but she starts by saying, "First things first, let's buckle those belts." I've even thought about trying to find out who this is, but I now tend to think that maybe it's a robot. She's so perfect that I won't Google it just in case. It would be a disappointment in these days of virtual reality. So first things first, let me explain what I will not mean by natural law today, so that you can buckle those belts, and then we'll move on to what I will mean by natural law today, and then we'll move on to natural law and constitutional law. So firstly, by natural law, I do not mean the singular of the term natural laws, where we typically mean what is meant by natural laws in the movie Doctor Strange, the new Marvel installment, where Doctor Strange has a device, a kind of watch, that he can move like this, and by moving it, he can break natural law, says he, meaning time. He can go back in time. So there is a guy called Mr. Wong who says to Benedict Cumberbatch, Doctor Strange, "Don't mess with natural law," meaning don't go back in time and change things. Well, I don't mean that by natural law, although it's a very valid meaning of the word, or to call natural law the law of gravity, for example, or the law that Darwin would describe when he would say, although I haven't read him, that big fish eats small fish and blah, blah, blah. Mine is not a natural law. My natural law is a moral law. So the word natural can be confusing, but I will retain it, and you will see why. So in this sense, natural laws are in a way removed from the domain of freedom, whereas, by way of contrast, the natural law I'm going to talk about is precisely about how we exercise our freedom. I sometimes like the analogy that natural law is like a whisper that we experience if we are very careful, by way of a kind of invitation for us to do what is right and to avoid doing what is wrong. So you see a $100 note that someone has dropped, and you're about to take it for yourself, and this whisper perhaps will suggest, you know, it is wrong if you keep this for you. You should try to find the owner. Now, if this is so, if this is an invitation, it entails that I can decide not to take it up and to steal in my example, which is something that differentiates natural law from natural laws. They happen by way of necessity, like gravity or time, for example, unless you have a magical device. So you need to want to do what is right. You need to want to go by natural law. If you don't want to, you break with natural law. You can't do that, and that is not true about physical laws, with some caveats that don't matter now. Secondly, and very importantly, I think, natural law, the one I'm going to talk about, is not a religious concept or term. And in particular, it isn't a Christian or a Catholic thing. Now, it is very easy to think otherwise, and this is why it's important that I take this up. And when I talked about this in the past, or I talk about this in class, immediately people say, oh, but this is, this is Thomas Aquinas, he was a saint. This is surely, well, it isn't. It isn't. Why isn't it? Because for religion, and in particular for Christian religion, you need faith. You need faith, which presupposes a revelation by God. So God reveals, and the person accepts by something we call faith. And instead, natural law, as described by, say, Plato, Aristotle, Thomas Aquinas, or the Pope for that matter, is something that appeals to reason only, without the need of the aid of faith. So the claim is that to know that it is wrong to take that $100 bill, you do not need to be a Catholic. You do not need to have faith in God or to know that he revealed a commandment that says, thou shalt not steal. Of course, some of the contents of my moral natural law overlap with some of the contents of some of the major religions, so much so that some of the proponents of natural law theory sometimes say that the core of natural law is encapsulated in the Ten Commandments of the Old Testament, of the Jewish law, but that something has a partially overlapping content doesn't mean that they are the same thing if they are relevantly different, as I think I've explained they are. So much different that I sometimes like to see natural law as the religion of those who do not have a religion or a faith. In fact, if you read St. Paul to the Romans, for example, he's talking to Gentiles there who by definition don't have a faith. And he says to them, if you do what you know in your heart that is right, then you are already doing the same that the Jewish guys do when they look at the revealed law. This, let's call it divine law or revealed law or religion, has something else in common with natural law, which may be confusing too, and that is that we can also resist it, unlike natural laws, scientifical, so to speak. So in this, religion and moral law, they both, at least when it comes to Jewish and Christian religion, they require freedom. And those religions define sin precisely as the willful, free opposition to the law of God, which you cannot say of the law of gravity. You cannot jump from the 5th floor and say, I want to be bad and I won't fall. You might be bad, but you will fall nevertheless. Is there a danger that someone might bring in their religion under the guise of natural law, that they may incorporate the catechism through natural law? Of course there is, and there is also the danger that jurists and judges and justices will manipulate, for example, French law or whatever foreign law in order to rationalize a given decision or solution that they find fitting. They can also use a law review article, for that matter, to disrespect the law that they should enforce in order to prefer something that they like better. And they can also do the same with religion. But this is not a reason to stop reading law review articles or dismissing French law, as I'm sure Olivier would agree, or to consider that natural law and religion are the same. Finally, this seems eternal, and I'm sorry, so many denials. Natural law is not what the US Supreme Court refers to under the description natural law jurisprudence in cases that go from Lochner to the revival of substantive due process in the 60s. So when the dissents, for example, in Griswold v. Connecticut, accused the majority of doing natural law, this isn't the whisper I'm talking about today, because this is only a domestic notion that has to do with something very removed from my notion of natural law, which is, simply put, it doesn't matter what the written laws of our country say or what our written constitution says. What matter is for us to do what we think it's just, whatever that is. And this very discredited notion of natural law under natural law jurisprudence, again, is not what I'm going to talk about today. So what is it that I am going to talk about today? I mean, I've talked a bit already. I could define my natural law as objective critical morality. So that would be a short, cute way of explaining it, because you have there the notion that this is morality we're talking about, the invitation, the flesh of this body that will be the law, is this morality, this inner morality, not any morality, an objective morality. So it's a morality that has a universality. If we go back to one of the first famous representations of natural law, a play that Pat Martin has taught here for so many years, Antigone or Antigone, it's there in that dialogue between her and her uncle Creon when she basically disobeys Creon's edict not to bury her brother Polynices. She says to him, look, I'm disobeying your written law, but there is a higher law. And this higher law, as it was said in my introduction, she says, is the same here and in Athens and in Sparta. So there is a spatial universality. And she goes on and says, this law commands me to do this right thing today, yesterday, tomorrow. So there is a temporal dimension to this universality. And when we say critical, in objective critical morality, what I mean is that I'm not talking about conventional morality, but rather a standard that will allow us to evaluate conventional morality as right or wrong according to the standards of this objective morality. More on this in a little while. I must say, when I speak about universality, that a certain amount of what we could call relativism is completely compatible with this notion, insofar as conventions, by way of contracts or laws, are crucial in order to flesh out what is morally right. As I will explain shortly, the natural law only gives us like the thick painting of the building, and there is a lot that remains still to be said, and then there's when convention comes in. And convention comes in, broadly speaking, through positive law. So positive law, or human law, what we call law, actually, is a great friend of natural law. Natural law is incomplete and needs positive law. And natural law theory holds that the positive laws of a given country, when they are just, are absolutely crucial to determine the just solutions to every single problem in that community. And in this sense, natural law theory is much closer to what could be termed as soft positivism than to all the fashionable theories of law that prevail today in US law schools, such as critical legal studies, economic analysis of law, or Marxist theory, or feminist theory, or realism, where in all of these cases, what the laws say doesn't really matter very much. What matters is I have a perception of what is fair or what is just. It doesn't matter if it's in the law. And then I try to justify it by going to one of these several possibilities I mentioned, which is why it happens especially in some schools, in some elite schools, that you have so many courses called law and literature, law and economics, law and blah, 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 because law doesn't really matter anymore. So if you want to be a jurist according to this theory, you don't need to know law, really. You need to know economics, psychology, philosophy, rhetoric, etc. Well, for natural law theory, law is a serious thing. The normativity of law is very important, and I'll come back to that. The content of natural law. This is like the difficult part, and I'll be brief, and you know where to find more on this. If you go, for example, to the writings of Thomas Aquinas, you will see that for him to identify what is the core of natural law, you need to look into the natural inclinations of the human being. For Professor Finnis, there are some he calls basic goods that you can identify as universal, that coincide with Aquinas' description, and from there, from those inclinations, from those goods, you can derive the first basic norms that have to do with the protection of life, that have to do with telling the truth in public, and so on and so forth. What you can call human nature, what it is to be a human person, is very important when it comes to this, especially at a foundational level, if not at an epistemological level. Of course, there will be disagreement when it comes to the content of natural law, when it comes to what is right, what is wrong, and especially when you go into very difficult moral questions. This is absolutely inevitable. There will be failure too in the enterprise of identifying what is right, what is wrong, what is natural law. But then again, failure presupposes a standard according to which something is right or something is wrong. So what matters really is to accept, if you want to buy into natural law, the idea that in practical moral matters, it is possible to speak truly. It is possible to say what you're saying is wrong, what you're saying is right, which doesn't mean, of course, to be judgmental, not at all. You're just judging the statements of a person. If you accept that you can say such a thing, what you're saying is right, what you're saying is wrong, then you are on board, basically, even if you don't talk about natural law, if you don't call it like that. Right. What are the goals? Now we start moving towards natural law and constitutional law. What are the goals of positive law? How does positive law enter in this picture? I would say three. In the first place, positive law makes natural law concrete. So there is like a process of filling the gaps in natural law. Natural law gives you a broad principle, you ought to keep your word, but then the law of contracts, for example, fills in the many gaps that you have there. Or a natural law tells you that when someone goes bankrupt, you need to give a fair treatment to all the creditors, but then comes in bankruptcy law and gives you all sorts of waiting periods and regulations and so on and so forth, the technique of the law. So the law in this first goal is mostly a tool to provide for coordination in the face of complex social problems that cannot be solved by natural law, cannot be solved by morality. Morality, in fact, requires that there be some kind of posited, authoritative mechanism of solution, law, positive law. This is why I was saying that positive law really matters for natural law. In the second place, positive law promulgates natural law. Typically, to begin with, by writing whatever it is the law. You need to keep in mind, going back to Antigone, that natural law is unwritten. There is this analogy that it is written in our hearts. When I used to teach this to my younger students in Argentina, where law is an undergraduate degree, they would look like this to think if they have something written inside their hearts saying, but of course it's not that. It's the idea of the metaphor of the whisper again. Instead, the promulgation of positive law is of a different sort. You have the records, you have edicts, you have the case books and all that, where you can read actually the law, so that no one can claim, oh, I didn't listen to the whisper, that said you shouldn't steal. Well, here you are. Enter the law of theft, for example, right? Thirdly, positive law supplements moral natural law with sanctions. Now, natural law has its own sanction. Antigone says to Creon that if she obeys him, and therefore she breaks natural law, she will be chased by her conscience her entire life. And she would rather go to jail, where maybe you could escape eventually, than never to escape your own conscience as a result of having done a bad deed. This, by the way, is another confirmation that Catholicism has nothing to do, because a Catholic would go to confession and then the conscience problem would disappear, but not for Antigone before Christ, a fictitious person anyways. The threats of positive law, we know, we have imprisonment, we have fines, we have jail, some sort of physical coercion, which is necessary and inevitable in our life, in our societies. When I mentioned to a friend who teaches in a small school, law school in Massachusetts, that I was going to talk about this with you today, he said to me, I'm quite okay with natural law. So he was the kind of person who knew what this meant. He knew this wasn't natural laws. He knew this wasn't religion. He knew this wasn't natural law jurisprudence. In fact, he knew what I was going to talk about. But he said it's totally irrelevant for the law. It has no traction whatsoever. That was the expression. So I will argue now in this part of my lecture, and I've already crossed the equator, in case you wonder, in favor of a certain traction for natural law for us lawyers, not for the ethics guys or for the philosophy department. So if what I'm going to say is true, there is a reason to teach natural law in a jurisprudence course in a law school, as it used to be the case, of course, always. Well, I suppose here it used to be the case too when you studied the civil code, until our dear Saul decided to remove the reference to natural law from the code, as I learned yesterday from Justice Wiener at Mary Joseph's house. So in the first place, speaking of traction, one benefit of natural law theory is that it helps to better understand positive law. It makes it more intelligible. And this is especially true about some areas of the law, those that have a closer and more direct connection to morality, to natural law. For example, some parts of criminal law that have to do with the law of murder, with the law of rape, with the law of theft, with the law of perjury. It's easier to understand them if you decipher the underlying moral norm to each of those positive enactments. Then natural law theory also allows us, I think, to criticize positive law. Professor Hart, who was supposed to be the new founder of new positivism, saw this very clear, that with conventional morality, you're dead if you want a tool to criticize existing laws. But if you hold that there is such thing as objective critical morality, which he did not call natural law, well, then you can say that such a law is unjust. The claim makes sense. It's unjust if you measure that law in light of this objective detached standard. So it's a great tool to evaluate. Now then, the evaluation may fail again if you start from the wrong moral premises, of course. I think there are, in the end, two different levels of traction for natural law. When you have in mind a certain field or segment of a legal system, you have a smaller traction. So natural law is less relevant. What do I have in mind here? I have in mind more or less 90% of the law of any given legal system. What Justice Breyer, in his famous debate with Justice Scalia on the use of foreign materials in constitutional adjudication, called, Justice Breyer, arcane matters. He gave the example, I'm sorry for you folks who teach contracts, he gave the example of contract law. He says this is a very technical area of the law, but the same is true of property law, and not to speak of IP law or things like that. Highly technically, way more relative, a lot of variation sometimes, way more contingency than in the other part of the law I'll refer to. So in what has to do with these aspects that amount to the vast majority of any legal system, law is, in a way, you could say, closer to engineering than to philosophy or moral philosophy. Legal reasoning, Finis insists on this, is highly technical when it comes to this. And this is why sometimes when a student comes to me fresh out of high school, their law is an undergraduate degree, and says, I love morality, I love philosophy, I want to study law, I say, no, maybe you shouldn't study law, because law is very technical, except for the other small part, where the traction of morality and of natural law is much bigger, and that's where there is a great overlap between moral reasoning and legal reasoning. But guess what? I teach that other part of the law, and this is the part of the law that brings us together today, because constitutional law, to a large extent, is precisely about not so much technical things, although there are, of course, many technical things. Well, first, if you think of fundamental rights, for example, you will notice that many times when you're reasoning about the restriction of a fundamental right, the kind of reasoning you do in law, in constitutional law, is not very different from the moral reasoning you would do about the same, say, for example, about euthanasia or about abortion. And then, of course, you have structure, which amounts to a vast part of constitutional law, although much to John Baker's regret, now is somewhat forgotten by people who teach constitutional law. But what about structure? Well, structure, too, it's absolutely at the service of those persons and their rights. So in an indirect way, it is also true that when you're talking about separation of powers or federalism, there is a lot going on in moral terms as well. And when we're talking about the traction, it's important to remember that labels don't matter. It doesn't matter if someone doesn't talk about natural law when they are doing constitutional law, if they realize that what they're doing has a critical moral dimension. I remember, in this sense, I was remembering yesterday that when after John Costonis actually called me to ask me if I would like to come for the first time, and we were exchanging ideas about what to teach, I initially thought about teaching a course called Natural Law or something like that. And John wisely would say to me, why don't you rather call it global law? You see, in those days, I knew less. So I thought this is not such a good idea. But now I think you know, the label doesn't really matter. I mean, you could call natural law global law if you want to stress the fact, which I have already stressed, of that generality, universality, etc. So it's important that we stick to the idea that this is about the rejection of relativism, strongly understood, and that you have some agreement around the core of what is right and what is wrong, then you are on the ballpark, regardless of whether you call it natural law or not. Right. I'm almost there. When it comes to fundamental rights, that's where the traction is at its higher level. It's interesting to note now that there is a development, a great expansion of human rights law at an international level. We can know that there is a certain convergence around at least the Western nations when it comes to the part of their constitutions that recognizes and regulates the rights. So natural law in that sense provides a great tool in order to explain why this is so. Why is it that so many constitutions defend, proclaim the same rights, you know, with some differences here and there, but you know, the universality Antigone was referring to is, I think, present in those repetitions. They can't be chance. So these areas of law, such as I said, some aspects of criminal law and many aspects of constitutional law, have a significant, let's call it natural, or if you want, moral content. So even though those moral contents, by definition, are now part of a positive law, say of a constitutional law or of a criminal code, they are still moral. It's as if there was some water there, that was the moral content, and now the water is in a glass. It is still water, even if it is in a glass. So in order to understand the glass with the water, you need to understand what that water is. And that's what I think natural law can help you to do. When Professor Finnis started writing about natural law many years ago, he was very wary about using the term natural law. If you read his book, Natural Law and Natural Rights, published in 1980, you won't find the word natural law. It's almost nowhere in the book except for in the title. But I think maybe times have changed a bit, and maybe now there is some kind of revival, perhaps because of this idea of the global and of the rights, or maybe because of Dr. Strange, which makes it less important now to avoid, I think, using the term natural law. In conclusion, I think that natural law is relevant for constitutional law. I think that it has traction, a limited but significant traction when it comes to constitutional law. And I think that reading a constitution in light of the distinction between the extent to which every part of that constitution is rooted in morality, whether it is more directly rooted in morality or in a remote way, it makes sense, that distinction, in order to understand to what extent natural law can throw light into the constitutional legal enterprise. Thank you very much.
Thank you very much, Santiago. Now, and I'm glad this was recorded, you came, to the point of the elimination of natural law from the Louisiana Civil Code, not citing the explanation that it has no particular meaning in Louisiana jurisprudence. You gave the answer, so what? Okay, it's everywhere in the code and the Constitution, and we have here some of a first-year students who ask me in legal tradition, Professor, can you give a brief, they're always worried when I speak, a brief definition of natural law? I'll give them now a link to this presentation, and they will be able to listen to your remarks. But I'm sure that there are questions from our audience, from our students and colleagues. Ken Levy.
Yes, thank you. I think that the distinction between the different levels in which a given positive enactment is rooted in morality, whether this is a distant or a close relation, is like the flip of the coin of the legitimate level of disagreement. In other words, there are many matters that are highly contingent, where the disagreement will be enormous. And then yet, of course, it will be true, especially in our times. I don't know if this was always like this. Maybe there was more similarity in the past in the views of peoples and nations. It will come sometimes to disagreement even about core questions such as abortion, euthanasia. Now, I couldn't argue here why any of these is right or wrong, but the underlying idea is that with natural law theory, one ought not to fear the notion that in such a disagreement, one of the parties may be right and the other one of the parties may be wrong. This which comes a little bit as shocking today, is, I think, at the core of the idea of natural law, because in the end, natural law is the admittance that there is truth in moral matters. So I know I'm not answering the whole of your question, but I suppose I will go from here.
I have a few of my students here sit with me and come from moral law. Tomorrow we'll study the fugitive slave clause on our way to Dred Scott December. So taking your template, would you consider whether or not the fugitive slave clause violates your canon of morality? I've got my own answer. I'd like to hear yours.
Okay, I like your socks, by the way. But, okay. Are you going to take a bus towards Dred Scott Sanford? You said you were on your way there? Okay, okay. Great. I don't know, Paul. I don't know sufficiently about those clauses in order to enlighten you. I would have to bring you to the podium, but maybe you can... Yes. Oh, okay. Well, slavery is actually a good example to bring us back to Ken's question, because with slavery, you have the very ironic situation where in the past, it was sometimes justified precisely as a confirmation of natural law. So sometimes when I talk about natural law, they say to me, and what about slavery? I mean, what about slavery of such a thing? Well, again, you know that, that in the past, slavery or whatever was considered right doesn't make it right or doesn't make it natural law. It merely means that then there was an equivocated understanding of that particular subject matter. It's the wrong label when it was called natural law. It was as bad as it is today. It's just that we came to understand better the nature of that practice. And unfortunately, it won't always be the case. With other things, it may be the case that as time progresses, we instead evolve, and in the past, maybe it was very clear for us that something was so-and-so, and now for some cultural reason or other, who knows, our conscience has been darkened, obscure, and now we hold right what indeed is wrong and was always considered wrong. Thank you. Yeah, yeah, the inner morality. Harvard. And what did he say? Right, right, right. Yeah, the book. Yeah. Yes. Yes, thank you. I agree with you that it's easier when religion is there, but in a pluralistic society, and especially under certain constitutions, it isn't an alternative in that it is ruled out of the public square. So the question remains, how does natural law do without religion, given that with religion it's easier? Well, I think it fares worse, I agree with you. And I think that if you try to find, without the aid of religion, the final reasons for what is right and what is wrong, you'll have a hard time. And especially you'll have a hard time arguing with others. These are the reasons for my reasons. These are the foundations for what is right and what is wrong. But if you move at a more superficial level, which is the only one we need for a day-to-day basis, then I think it won't matter very much what you hold about human nature or Freud or anything. You see, you will think, for example, I am driving home, and there is a person there who has had an accident and is gravely injured and it perhaps is about to die, and I want to watch the Super Bowl, you know, and you will be posed by your own conscience the question, what ought I to do in this situation? And I am quite confident that you will know what to do, and then will come freedom. You know, you may still go see the Super Bowl. So I think that's the level where you won't have trouble most times for your decent, average person to know what is right and what is wrong. And that's what natural law is. Then when you want to know the whole theory, yes, I think you will experience many difficulties. Yeah.
They are good at reading positive law. They are good at reading contracts. They are good at reading statutes. They just don't do natural law real well.
Yeah.
And I guess my concern is, and it's one I've wrestled with, is that precisely because we have not, for 10 generations, we have not trained people to do it well, it really does become such an open door for importing Northwest policy. Which is only the weakness of the problem. So, I mean, I'm with you that this is where we ought to be. I just don't know how to get there. And I'm curious if you have thoughts about how that tradition can be recovered in the absence of the scholarly foundation, the education foundation.
Thank you. I mean, you give me a great opportunity to make the public advocacy of my own teaching and writing. Yeah, I mean, the problem is, of course, that what you want today, unfortunately, law schools to do is precisely not to do that. You just want the law schools to teach practical skills and all you see in the front page of whatever magazine I picked up over there. But I think it's very clear that what one needs to do, and it's been done by some people, is to go back to the basics, have people read the classics in a jurisprudence course or in some aspects of constitutional law. You know, you can go back to some Plato, some Aristotle, some Kant, and I think people like it. You know, they get it. They understand it's useful. You're quite right. It's there in the tradition. There is the whole idea of natural rights that has to do with this, to what extent it needs to be studied. And then students have like a new torch. They can understand better whether Scalia is or not a natural law guy. Is he the positivist? Is he not? I think it's worth the while. You would be forming like different lawyers.
Yeah, I'd like to pick up on what John Christone mentioned and also what Ken mentioned by referring to an article by Eric Logan. I'm sure Tim Stone will correct me if I don't have the title right, but my recollection is that the title was Being an Exist, something like that. And anyway, in the beginning of the article, he notes that we can't talk to one another today. And he said that Thomas Aquinas and the Arab world have no difficulty talking to one another. You know, the Arab world rediscovered Aristotle taught back to the West. It was, and I like to emphasize this, it's really, as Bob Pascal used to say, a matter of natural reasoning. And his point was, in the modern world, we have a loss in front of most people of ideology. And because of that ideology, and it can be right, left, or whatever, wherever, that loss prevents people from engaging in the natural exchange of reason. And this is really an epistemological question. You mentioned that word once, but I think that goes to the heart of relativism.
Yes, I hear you in a way not too different from Professor McIntyre's idea that in After Virtue, the way it starts, that today philosophy and ideology are so fragmented that it's not possible to have the kind of dialogue that, say, you could have in the Middle Ages or you said in the Arab world or whatever. I mean, this is, of course, true. This is why I said it would have been easier, maybe it was easier, maybe it would be easier if, but this is what we have. This is the world we have. It's a world where there are many divisions, many disagreements, and I still resist that there is no alternative to mere power and whim. I still think that regardless, it is worth trying, of course, without an enormous optimism, to try to understand each other when it comes to these difficult moral questions, and to try to argue, and then you argue using, as you say, right reasoning, and to point out to faulty reasoning when there is one, comes from the wrong premises, and so on and so forth. And without, as I said, the fear of saying, look, I think that what you're saying is not true. Is this the solution? Is this like a perfect scenario? No. I think, though, that there isn't a better one. That's what I think. Can't think of of something better. Was natural law more fruitful in other times? I think so, probably. Jim, I think, has a question.
I was curious and somewhat surprised by your relating contemporary Western human rights to natural law. I could see that several hundred years ago, the early notions of shared rights of man or of natural rights had a foundation that at least interlocked with tradition, the tradition of natural law. But it seems to me today that
Thank you.
But in particular, I wonder today if human rights is a threat to natural law or if it's become on a kind of collision course with it.
Yes. I think we should distinguish between the politics of human rights and campaigns and so on and the documents. So if you look at the documents, although things may change and there is a state of flux, I go, for example, to the Inter-American Convention on Human Rights, the Pact of San Jose de Costa Rica, or the UN declarations. I mean, they are perfect. There's nothing there that I can see that is not like strictly derived from natural law. I mean, there is some room there for variation in the concretization, but then again, the variations are also unimpeachable from a moral point of view. You may like them less or more. So I still think that those documents and the ACHR 1950, the European Convention on Human Rights and Fundamental Freedoms, they are very much in line with natural law and with the way constitutions such as the German Basic Law or to the extent that the U.S. Constitution has rights, the U.S. Constitution recognizes rights. I think there's no problem there. Then, of course, there are problems at the political level, at the level of interpretation, implementation. Some case law, say of the U.S. Supreme Court, one could say this is at odds with natural law, or some international bodies that monitor some conventions, they come to conclusions which are at odds with natural law. Yes, I would agree with that at a general level. Interestingly, though, when it comes to abortion, I was in a meeting a few years ago in Costa Rica, precisely, where a group of scholars drafted the so-called Articles of San Jose on the right to life in international law on human rights. And we went through all the documents then. This is like 6 years ago. And there was nothing binding, legally binding, against the right to life from conception. So then when it comes to the newspapers or to executive action, campaign, money, funding, it's all more about whether Trump, Obama, or who comes next, or who is in the United Nations. But that's not what I had in mind when I said what I was saying. Yeah.
But isn't the problem more fundamental than that? Because I agree with you that helpful is what you just said. But Jim Stoner can derive principles from what he sees as Aristotelian or Thomistic principles and come to one set of conclusions. I might do the same thing, come to a different set of conclusions, perhaps precisely on the issues that you raised. And yet, both of us, maybe one, at least one of us is wrong, maybe both of us. How does one ever get past that? You know, there is something fundamental that there is a
Yeah.
divergence that does not seem reconciled.
I think what there is fundamental is our ability to get things wrong or right. So maybe he will never get past that, or maybe you won't. I don't know. We'll have to go through whatever thing we're talking about, and go through it consistently, honestly, and it's a hard way. There isn't a prefabricated answer to the problem. But what I think there is the optimism that it is possible to get it right. Can I promise you that I will ever get it right, or you? No, I can't. That we know, we can get it wrong. But then wrong means there's right. Yeah. No, it is. It is helpful, and in fact, there has been a trend for the last 20 years towards, with the same goal I presented today. There has been a trend by thinkers such as Alexi, for example, in Germany, towards going back to basics in what comes to procedure in reasoning, public discourse, so that you reach the right conclusion. So I think that is very important. But if you start from the wrong premises, you know, you may end up in a situation like Professor Fuller described to Pablo in Harvard, where you will have a perfect razor now, impeccable razor, but maybe you will use it to kill someone. So it's unavoidable that you will have to include into the procedure part some substance and some dialogue and debate about which substance.
One thing is sure at the end of this conversation is that we ought to extend an invitation to Santiago to come and teach, whether we will call it natural law, global law, Aldine, Tom, well, universal. Okay, you have your title now. And I would certainly encourage, you know, everyone, you know, Jim Stoner brought the abortion thing, processes, reading the German decision of the Bundesverfassungsgericht on abortion is just illuminating in many respects. And, well, okay, that may be another session that we could have, another discussion. Well, on behalf of everyone here, I would like to thank you, Santiago,
so much.
for
Thank
this
you.
most inspiring remarks. Merci.
Thank you very much.